Good morning. Today we're going to continue with legal liability and we're going to continue with common law. Everything we're going to talk about today relates to common law. Remember, as previously, each state has its own body of common law, but there's three significant trends. There's those states that hold auditors liable to primary beneficiaries for ordinary negligence. There's those states that hold auditors liable to foreseen parties or foreseen users for ordinary negligence. And there's those states that hold auditors liable to foreseeable parties for ordinary negligence. We're going to make up a case and see if we can sort that out and make it a little less confusing. So we're going to start out in the state of New York. Now, Professor Burgunder explains to me that whenever there's a case, if it's a big case, they do what they call venue shopping. The plaintiff may want it in a different state than the defendant. So how do they settle it? Well, the three most logical places to hold a trial are in the state where the transaction occurred, in the state where the plaintiff lives, and in the state where the defendant lives. So in our case, we're going to have everything in New York. The transaction occurred in New York, Mary lives in New York, Car Sales Inc. resides in New York. Mary bought some Car Sales Inc. common stock. We don't know how she got it, who she bought it from. Car Sales Inc. is not publicly traded. It's a private company. They're not required to file with the SEC. Car Sales Inc. had their financial statements audited, and they told their auditor they were having their financial statements audited in order to get a bank loan. Car Sales Inc. suffers a major loss and is going bankrupt. We're in New York. It's a state court. Mary files a common law claim in New York. Mary can show the auditor was negligent, to which case will the auditor look, or pardon me, not the auditor, to which case will the courts look for guidance, and is Mary likely to prevail? New York, the courts will look to Ultramaris and Credit Alliance as precedent, and they will also refer to those cases for guidance. Particular purpose. The auditor understood, so the two pieces, big pieces for primary beneficiary are the auditor knows the purpose for which the financial statements will be used, and the auditor knows the party who will rely on the financial statements. So purpose, the auditor understood the financial statements would be used for a bank loan, not to purchase common stock. So the auditor is not going to be liable. Known party, primary beneficiary, Mary is not a known party. The auditor didn't have any way of knowing that Mary would rely on the financial statements. So again, this is a second reason the auditor would not be liable. In New York, auditors are only liable to the primary beneficiary for ordinary negligence. If it's gross negligence, constructive fraud, we would expect the auditor to be liable to primary beneficiaries, foreseen users, foreseeable users, in other words, to all third-party investors. But for ordinary negligence in New York, auditors are only liable to the primary beneficiary. Let's move the whole kit and caboodle to Rhode Island. So Mary lives in Rhode Island, Car Sales Inc. resides in Rhode Island, and the transaction occurred in Rhode Island. Mary bought some common stock. Car Sales Inc. is a private company. It's not required to file with the SEC. It's not publicly traded. They had their financial statements audited and told the auditor they were having their financial statements audited to get a bank loan. Car Sales Inc. suffers a major loss and is going bankrupt. We're in Rhode Island. the state courts of Rhode Island. Mary files a common law claim. She can show the auditor was negligent. In Rhode Island, the courts will look to rush factors as a precedent and for guidance. Now, for foreseen, I'm going to use the material related to the second restatement of torts. It's easier for me to understand. Again, there's two pieces, the type of transaction and the first party relying on it. It has to be a specific type of transaction or a substantially similar transaction. The auditor understood the financial statements would be used to get a bank loan, not to purchase common stock. The auditor would not be liable because it's not a substantially similar transaction. Foreseen is one of a limited group that the auditor knows the client intends to supply the financial statements to. So in this case, any bank would be a member of that limited group. Mary is not one of the limited group. So for a second reason, Mary will not prevail in this lawsuit. In Rhode Island, auditors are liable to primary beneficiaries and foreseen users for ordinary negligence. Auditors would be liable to all third-party investors for gross negligence, recklessness, constructive fraud, or fraud. Well, let's move our example to Mississippi. There's only two states that adhere to the foreseeable user theory, Mississippi and Wisconsin. So we'll pick Mississippi. Mary resides in Mississippi. Car Sales Inc. resides in Mississippi. The transaction occurred in Mississippi. Mary bought some common stock in Car Sales Inc. Car Sales Inc. is not publicly traded or required to file with the SEC. Car Sales Inc. told their auditor they were having their financial statements audited to obtain a bank loan. Car Sales Inc. suffers a major loss and is going bankrupt. Mary files a common law claim in Mississippi. She can show the auditor was negligent. The courts in Mississippi will look to Rosenblum as a precedent and for guidance. Mary's going to prevail against the auditor in Mississippi. Virtually anyone who relied on the financial statements would be considered a reasonably foreseeable party. In Mississippi, auditors are liable to virtually all third-party investors for all ordinary negligence. Here's the handout again of the states which adhere to the primary beneficiary theory, the foreseen class, and the reasonably foreseeable. The only two states that still adhere to the reasonably foreseeable, or Rosenblum, are Wisconsin and Mississippi. Thank you. There is an additional presentation tomorrow. We'll cover statute law. We'll take our Car Sales Inc. and we'll see how it applies to statute law. Thank you.